Welcome everyone. My name is Brody Smith. I'm an attorney at Schoeneck King. I'm a member in our Syracuse office, and today we're going to be talking about land use issues related to cannabis. Just to give you a little bit of my background, I do a lot of zoning and planning work, a lot of work on the developer side, that sort of thing, but also I spend about half of my time representing municipalities where we are either the town or the village attorney, or sometimes we're special counsel for cities, villages, and towns where they have particularly contentious zoning issues where they need representation for planning boards, zoning boards, or the elected board in the case of amendments and PUDs, that sort of thing. A lot of that involves SEQR, the State Environmental Quality Review Act, and all the different issues and litigation that proceeds from that. So with that introduction out of the way, I'm going to get into our topic for today and share my screen. So today we're going to be talking about land use issues related to cannabis. The different topics that I'm going to cover here today involve the state licensing system, including the notification process to municipalities and ways that municipalities can respond to that notification process. Secondly, complaints and enforcement actions against either licensed or unlicensed cannabis businesses that violate the law. And then finally, local land use regulation options available to municipalities in order to enforce additional land use, time, manner, use restrictions on this particular activity. So I like to begin any presentation on a topic like this with some definitions so that we're all on the same page as to what we're talking about. Cannabis refers to more than just one part of the plant or one thing. So I'm going to take a moment here and I'm going to read to you the definition of cannabis, slightly reworded from the regulation in order just to be a bit more readable. So it's all parts of the plant from the genus Cannabis, whether growing or not. It includes the seeds, it includes the resin, and every compound, manufacture, salt, derivative, mixture, or preparation of the plant. That includes its seeds or resin, that includes mature stalks. It does not include, I should say, mature stalks of the plant, fiber produced from stalks, oil or cake made from the seeds of the plant, or any other compound, manufacture, salt, derivative, mixture, or preparation of mature stalks, so on and so forth. It does not include hemp. So therefore, when we're talking about cannabis, specifically, a lot of this conversation is going to talk about retail dispensaries. So a retail dispensary, it follows, is a business that engages in the retail sale of cannabis products. And then finally, the retail sale of cannabis products means to solicit or receive an order for, or to keep or expose for sale, or to keep with the intent to sell cannabis products. And in that definition, you see a licensed person. So under the state regulation only, the retail sale of cannabis products only applies to licensed, not unlicensed sellers. So the first thing that I wanted to talk about is something that's probably been come up for a lot of you, is you receive a notification to a municipality of the intention of a dispensary or an on-site consumption business to apply for a license. So pursuant to Section 76 of the cannabis law, within a certain period of time, any applicant for a retail dispensary, cultivator, that cultivator's category, by the way, is often referred to as an ROD, so a registered organization, or a on-site consumption licensee. That notification that goes to the municipality is part of the application process. So that notification that that shows up at the town, it is an opportunity for the municipality to provide comments to the state regulators who are trying to decide whether to issue a license to that dispensary or on-site consumption business applicant. So the notification has to be received by the municipality in certain ways: certified mail, overnight mail, or personal service. So one thing to check is, to make sure that you received your notification in the correct manner. Also, this isn't applicable yet, but it will be. These licenses only last 2 years. So you'll be receiving these notifications with regularity in the future, because every time someone applies for renewal of an existing license that they already possess, they're going to have to go through the same notification procedure, and there'll be an additional opportunity for the municipality to comment, in this case, not just on prospective issues, but you would have the opportunity to observe the business in action for 2 years, and you can provide comments as to their performance or compliance with the regulations that you had the opportunity at that point to observe for a period of time. So the municipal response to notification, in the Office of Cannabis Management, it's a New York State office, there is a municipalities frequently asked questions section. So I took a lot of this information from that FAQ, but there's a lot more there than was appropriate to share in this presentation. And it's worth reviewing if you, as a municipality, receive a notice that requires a response. That municipality FAQ is very helpful in going through the response process. So you should respond if you have an opinion as to whether or not the cannabis board should issue the license. Now, that response to the notification needs to include certain information. It needs to include the application ID number, the business's legal name, the name of the applicant, and in detail the reasons for recommending the granting or denying of the license. And you should organize your response to the notification in that way. I've also included on this slide on the left, there is a guidance document on the OCM website that is state requirements for adult use retail dispensary licenses. And in that document, it goes through, from the applicant's point of view, all the different things that they have to provide and all the different issues they have to address. So I think it's also very useful for the municipality to be familiar with those different, with that information, I should say, because that is the information that the state is going to use to decide whether or not to issue the license. So I think it's very useful to have that set of factors or those considerations in front of you when you're crafting your comments on the notification and expressing the opinion of the municipality. So what are specifically those dispensary approval factors? First, they look at the character of the other licenses in proximity to the location in that particular municipality or subdivision of the municipality. The reason for that factor is so that one particular community doesn't get inundated with all the licenses and other communities receive none. That sort of goes two ways. It goes two ways in terms of communities that are competing for the licenses that want them, but also communities that would be interested in having one or more licensed businesses, but don't want to be the epicenter of that activity. They want to have a limited amount. So I think it cuts both ways. And that is an appropriate thing to comment on in your opinion letter in terms of the concentration of these businesses in one area or the other. Evidence that all necessary licenses and permits have been obtained from the state and all other governing bodies. Now, an applicant can apply either preliminarily or a final application, and sometimes you'll receive a notice for someone who hasn't yet obtain control over the property, so they're unlikely to have all the licenses and permits. Other times, you'll receive a notification after certain zoning approvals and other types of approvals have been obtained. It's important to express to the state regulators, where they're at and what they would need in terms of local approvals under that subdivision. Third, whether there's a demonstrated need for such a license, and that goes to the needs of the community and whether there's an interest in the community or a need for someone to supply this particular service. Fourth, the effect of the grant of the license on pedestrian or vehicular traffic and parking in proximity to the location. The state is very deferential to municipalities who have more information about pedestrian safety, safe ingress and egress, the adequacy of local infrastructure with regards to traffic, and the adequacy of proposed parking plans. And I do think they're interested in local input on those issues. Existing noise levels at a particular location, any increase in noise level that would be generated by the proposed premises. That's going to be very different depending on the status quo context that the business is attempting to enter into. So if you've got a downtown area with a lot of businesses, walkable city or village center type situation, that's going to trigger a certain level of scrutiny with regards to noise versus if you're locating in a more, suburban retail type context, strip malls or a standalone building surrounded by parking where there could be single family residential in proximity to this business. That's going to really make a big difference as to whether or not the noise level could have a negative impact on neighboring property owners. And then the state says any other factors specified by law or regulation that are relevant to the determination that granting a license would promote public convenience and advantage in the public interest of the community. So anything else you could think of, I suppose, is the way to think of that one. Is there a limit to the number of licenses that will be issued to one municipality? No. But like I said, one of the factors that the board considers in Section 10 under the law is the concentration of these licenses in one particular neighborhood or community. And the board has discretion in to limit that number, discretion as to where the licenses will be issued. And I do think that local municipalities should express a clear opinion on that topic when you receive these notification letters from applicants and from the state. So the office is going to review, this is the state regulators, are going to review the following items as well when deciding whether or not to award a license. They're going to consider the opt-out status of the municipality. And I'll talk more detail later about opting in and opting out, but I think most of you are probably familiar with that since that was such a big topic of conversation a couple of years ago. The distance from any existing medical dispensary. And then as this moves on, the distance from any existing license holder, because at present, there's not that many, but soon there will be many. The distance from any existing or proposed dispensary, like I just said, whether there's a house of worship on the same road and within 200 feet, whether there's a school on the same road within 500 feet, and then section 119.2 inserts this prior existing use concept, which will be relevant later. And that's the situation where a dispensary is located in a certain location and a house of worship or a school is then after the fact located within that 200 or 500 foot radius of this existing business, then that's not going to count against them to close an existing business or count against a renewal application if they pre-existed that house of worship or the school. Proximity to other dispensaries has explicit distances set forth in the regulation. So unless explicitly approved otherwise by the office, a dispensary can't be located anywhere within a radius of another premises that's already licensed as a dispensary or a medical dispensing facility. And so that radius depends on the size of the municipality. If it is a small municipality, so less than 20,000 people, it's 2,000 feet. If it is a larger municipality with 20,000 people or more in terms of population, that radius is reduced to 1,000 feet. So this radius applies to other licensed cannabis businesses. So just to review, I'm going back one slide for a moment. 200 feet from a house of worship, 500 feet from a school, and then assuming for this example, you're in a municipality with fewer than 20,000 people, it's got to be at least 2,000 feet from any existing licensed dispensary or medical dispensing facility. I'm going to talk a little bit about complaints and enforcement. This is a hot topic that's been in the news quite a bit in terms of there's sort of two ways to address it. One, you report violations to the state. And as you look at the regulations that came out in March of this year, there's really an assumption that that's plan A, right? That any sort of violation in two categories. First category being you've got a licensed dispensary that's not following the rules. I think there's an assumption from the state that you're going to report not following those rules to the OCM, to the state agency, and then they'll use their enforcement provisions to then pursue that potential violation. And they have a lot of administrative remedies at their disposal. They could issue civil fines. They could, begin a process to potentially revoke the license. That's all available to them. The other category where the state could be involved is where you have an unlicensed cannabis business. They also have expressed an interest and an intention to engage in the enforcement and regulation of those businesses. So those are the unlicensed smoke shops, as they're commonly known, where cannabis products are sold, but the owner has never bothered to obtain a license. So there's also enforcement from the Office of Cannabis Management available, in those situations as well. The second topic that I'm going to discuss as part of the complaints and enforcement portion of this presentation is your local enforcement options. So what can the municipality do in addition to or separate and apart from whatever the state regulatory enforcement options are? So the first option, and there are advantages to it. It's relaying to the state information about activities that may be in violation of the cannabis law. And I think one of the advantages to it is it's cheap and it's relatively easy to do. If you go to the OCM website, there is an online link where you can basically fill out all the information on an online form and hit send. So in that sense, you don't incur a lot of expense in terms of legal fees or a lot of time and resources in terms of local code enforcement or local police resources being devoted to enforcement actions, either in village court or in front of zoning boards or planning boards, that sort of thing, which takes time and money and effort. Time in terms of the time of your employees of your municipality, your town, village, or city, and then money in terms of paying outside attorneys and that sort of thing to try to enforce these on your own. So one big upside of the complaint filing system is that it's relatively cheap and relatively easy to do to get something on the OCM radar by using their online reporting function. So the Office of Cannabis Management has this incident reporting form as well. And that is separate and apart from what I just described as the complaint the complaint form. This other form, this incident reporting form, has to do with the situation where you've got a licensed cannabis business. So it is a legal business, but there's been an incident with someone having negative health consequences from products being sold, and that sort of thing. And so there's also a separate incident reporting form for that. In theory, all these licensed businesses are supposed to have their product tested to make sure that it's safe, and there's certain regulations in place to ensure that it's a safe product in the same sense as, like, a food product sold at retail in a grocery store, that sort of thing. And if there are violations in that sense, meaning there are complaints in your community of people getting sick or having negative health effects by virtue of using products that were sold by a licensed facility, this is the form that we'd use for that, the incident reporting form. So when you file a complaint with the state, you need to include certain information in order for them to respond. The name of the business, obviously, the time of the alleged illicit activity, the location of the alleged illicit activity, pictures of the alleged illicit activity, indicate if there has been previous police contact. So that could take the form of 911 calls and also police reports. Proximity to sensitive locations. So we talked about schools and houses of worship, even if they're not within the certain number of feet that we talked about, 200 and 500, if they are in the area, they want to know that. And contact information of the person reporting the alleged illicit activity, i.e. phone numbers. I would think emails would be a wise thing to include in case there are follow-up questions. So look at this list of information. It's not, filling out a form saying this is an unpopular business and we think they're doing illegal things. The state's looking for really specific evidence that they could then use as part of an investigation that could end up in an administrative court context where they would have to prove that certain violations occurred with admissible evidence. So they want specifics. If you send pictures, you need to include the contact information of the person who took those pictures. If you have witnesses who witnessed illegal activity, you need to provide the identities and contact information of those witnesses because they may be called upon to testify. So you have to think of this not just as, in the context of like anonymous zoning complaints, the business on this corner is too loud and we don't like it. The state's really looking for something a lot more specific than that. They're looking for information that they can then use in a court type setting and prove that there have been violations of the license. So I think that's a higher bar than most municipalities are assuming when providing a complaint. And I think it's important to keep that in mind if you have a business that is problematic in your community, that it's worth putting some time and effort into obtaining the specifics of your complaint. It'll be more likely to be acted upon by the state if you provide that sort of specificity. Because then from their point of view, from a prosecutor's point of view, they're going to see evidence that they're more likely to be comfortable acting on, that they could go then and get a conviction and some consequences to the violations. Now, that being said, in fairness to us complainants, not from the state's perspective, they are supposed to be investigating these things and they have a budget to investigate them. And the other way to look at this is I provide you with the complaint. I tell you where there's smoke and I expect you to go in and investigate and find the fire. And I think that's a fair point of view. But what I am relaying to you on this slide is the list of things in the state's guidance documents that they direct municipalities to provide. They're asking for this information. And I think you're more likely to get their help from the state if you have this type of information included in your complaint. So what are the kind of things you could you would complain about? Well, I think outdoor signage is going to be a big issue. There's a ton of rules, and this is not nearly all of them, but these are some highlights that I think are most likely to come up in terms of, you know, improper signage. And I think at the early stages too, if you spent any time in New York City, I think you'd realize real quickly that none of these rules are being followed, you know, in Manhattan, for example. There's just violations left and right of the signage regulations. And for whatever reason, it seems like amongst the regulated community, there's very little understanding of it. So let's go through a couple of the highlights. So outdoor signs can be used to advertise if they're for the purpose of alerting individuals to the location of the dispensary, right? So these are what we call in zoning and planning parlance, directional signs, signs that aren't purely, you know, for an advertising purpose, but for the purpose of directing people in cars or people on foot to the location of the business that they're looking for. So oftentimes, you know, when I've been on the developer side of applications and, you know, my client wants to have a huge sign on front of their business in order to catch people's eye going by who aren't necessarily looking for their business, I've been told by, you know, by a planning board chair, you know, that we license buildings, not billboards masquerading as buildings, right? So the same sort of thought process, I think, is what they're talking about in this first bullet, that they should be directional signs, not massive billboards attached to buildings. They're limited at a maximum to the following information. And that information is the licensee's name, the entity name that they're using to do business, their address, their phone number, their email address, websites, and the nature of the business. They need to be affixed to a building or permanent structure. You may not cannabis businesses may not advertise on billboards. That's a quirk of the law. They've been frozen out of that particular type of advertising. They can't advertise on vehicles. They cannot do not total more than 2 in number per licensed premises. You can't have more than 2 signs on the building for each licensed premises. And then any marketing or advertising is prohibited on any signs or placards, regardless of size or purpose, in arenas, stadiums, or their sporting venues, shopping malls, fairs, or video game arcades. So there's certain types of businesses or certain types of public gatherings where cannabis advertisements are not permissible. So the reason for going through this in such detail is I do think if a municipality is dealing with a cannabis business that is not following the rules, I feel like this is one of the first rules they're going to break. And it's worth documenting any of these things that you see if you're thinking about then later submitting a complaint. The advertising, there's certain prohibitions that with regard to content, they can't depict any non-compliant cannabis products, so it can't depict products that they can't legally sell. It can't display images or audio that's designed in a manner to be attractive to people under the age of 21. They can't display colloquial references to cannabis or depictions of cannabis products or paraphernalia, or people in the act of smoking or vaping. So colloquial references refers to slang for marijuana. So, pot, weed, anything like that cannot be part of a advertising for a dispensary. They can't promote price reductions, coupons, discounts, loyalty programs. It can't be, like a mattress business, everything's 50% off. They can't do that. And they can't make representations about the safety of cannabis products on their advertising. They may not advertise through free promotional items, including gifts, giveaways, discounts, reward systems, free or donated cannabis products. There are exceptions. Those exceptions include this environmental sustainability program that has to do with packaging, but it's a fairly narrow exception. I'd say for the most part, they may not use those promotional items. The packaging has to include certain warnings. So it has to show that it's THC. These are different variations in the regulations of what the warnings can look like, but it really has to be one of these three. And it has to show that this product is only suitable for people over the age of 21. They need to have certain security plans. And if you look at the regulations, the security regulations are very detailed. And again, this is just a fraction of it. But I think these are the things that would be evident to you as a municipality looking from the outside in. There needs to be some plan in place to prevent loitering and ensure that only individuals who are shopping there remain on the premises. It's not supposed, like a dispensary is not supposed to be a hangout. You're not supposed to have people, even in an on-site consumption license, you're not supposed to have people milling about outside who aren't, in there using the product. They have to ensure that both the inside and the outside perimeter are under video surveillance and they're sufficiently illuminated so that they're safe in terms of lighting during nighttime hours. And then they have to maintain any landscaping, like trees and bushes and foliage and that sort of thing, to make sure that it's safe and that there aren't people concealing themselves from sight in those areas at any time. Also, there's certain places that a dispensary, businesses it can't be married with, right? So a retail dispensary can't also sell food. They can also sell beverages or personal care items. So it can't be in a deli or a gas station. You can't have a dispensary located in a business like that's piggybacking off that other business. It has to be separate from those types of activities. I want to talk a little bit about legal versus illegal dispensaries. I mean, one of the things I think a question that I get quite often is some business moves into town, they're selling marijuana, and the knee-jerk reaction from the codes officer, the mayor, the supervisors, are they allowed to do this? And how do I know? So there is a dispensary location verification database on the OCM website that includes all the licensed dispensaries. It is not a huge list yet. So you can use that database in order to look up whether the dispensary in your town is actually licensed, and it provides information in terms of the licensee's name, the corporate identity of it, the street address, the city, the zip code, and an email for that business. So if you have a business that's moved into your town and you're not certain whether it is a licensed cannabis dispensary, one way to figure that out is to go to the database. The other way that should be evident is they're required to have the sticker on the front window of the business with a scan to verify QR code. And if that sticker is not there, you should be suspicious, right? And certainly go and check the database. So what is an illegal cannabis business? The city of Ithaca, I thought, had a really interesting FAQ on this subject on their website. And they say, is the sale of cannabis legal through the gifting loophole in the act? And the answer is no. Unlicensed cannabis sales remain illegal in New York. If you don't have a license, you can't sell cannabis. As the New York State Office of Cannabis Management announced, recent media reports have described business operators selling a product or a service, including club memberships, to consumers and providing cannabis as a gift in return for joining a membership in a group. This activity is illegal. These violators must stop their activity immediately or face consequences. Among those consequences, OCM has announced that violators will risk the opportunity to get a license in the future. And there's possible criminal penalties and administrative fines. OCM is seeking reports of violators to the OCM enforcement function. And then they say the local police are also interested and would like to know if you have information about a business like this. So you saw this all over the state, and there were literally thousands of these businesses in New York City at the beginning of this year. where the idea is we don't sell cannabis. We sell memberships to a club and you get cannabis as a gift for joining our club. Or we don't sell cannabis. We sell t-shirts or stickers or something else, and you receive cannabis as a gift. And so therefore we're not selling cannabis and we're not violating the law. And this is nonsense. There's nothing to these assertions of this, bizarre perceived workaround from the law. And I don't think anybody from the state ever recognized it as such, even though if you talk to these business owners, oftentimes, they'll be vehement that, what they're doing because you're buying a sticker, you're not buying the cannabis, that somehow that means the law doesn't apply to them. And it's nonsense. I said even Ithaca thinks so. When I was researching this, there's a Politico article that was calling Ithaca Pot Town, New York. So even Ithaca is with me on this. They are cracking down on it just as hard as anybody else. In the state budget this year, because this was such a problem, it was reported that included in the budget was legislation to provide resources for enforcement. And the legislation empowers OCM, to do more enforcement on these illegal storefronts and trucks, and gave them the ability to assess civil penalties with fines up to $20,000 a day for the most egregious offenders. And they tasked them with making sure proper taxes are being paid and that the regulations are being followed. And specific statements against, like I said, sticker shops or gifting schemes was really the object of this new program in the state budget this year. Governor Hochul, beginning in the summer, made announcements of the beginning of enforcement actions this is an early press release from the governor's office. The numbers went up from here over the course of the summer of thousands of pounds and millions of dollars of illicit product being seized by the state. But after all that, maybe not. Not too long after that, this is from an article in late October, it became known to the media that state cannabis agency, the OCM, had paused trials for a lot of these unlicensed shops. So they had these very dramatic raids, police and like SWAT type gear and that sort of thing, raiding these businesses and taking illegal product from them, and then threatening major fines. But there's this administrative trial process, and when the rubber met the road in terms of securing convictions, the state has pulled back a bit. And in the media, it's being reported that they really haven't pursued very many of these potential tickets at all, right? So they conducted the raids, but then when the time came to seek convictions in the administrative courts, there seems to be some reticence from the state. So and this tracks, by the way, with talking to my municipal clients who've had issues with this, they call the state, they fill out the form, and sometimes there's just no action. They talk to their local elected representatives, and they sometimes get the message that the state, this isn't they're not going to pursue it for whatever reason. And so then the only option left in municipalities is to seek options of local enforcement. So what are your local enforcement options? You can use, especially villages, oftentimes have local police forces. You could use local police. You could use nuisance laws, which I'll talk about in more detail. And then you could also use zoning or land use violations to try to enforce rules against these businesses. Nuisance laws are controversial. I have to say that up front. That's where businesses acquire points for police calls or convictions of minor violations of either the penal code or the zoning law. And eventually, when you acquire enough points, then the city will close that business down following some sort of hearing. And so it's an option, but it's not an option that doesn't sometimes attract some criticism. In order to have to write a nuisance law and apply it in a way that it'll hold up under judicial scrutiny, you have to very carefully define what a public nuisance is. The best way to do that is in your law. You list all the different infractions of the penal code or of your zoning code that would qualify, excuse me, that would qualify as point violations under the nuisance law. So you list them by code number. And then you provide a process by which the police or the codes office can give notice of violations. There has to be some sort of waiver process, because really what you want to happen under these nuisance laws is for businesses to come to you and say, I'm sorry, we won't do that anymore. And so you create a process by which they agree to, remove the thing that's objectionable, repair it, stop certain conduct within a certain period of time. And if they do that within a certain period of time, the points will be forgiven. And that's really what you want as your primary resolution for most of these, is you want compliance, right? So you need to create some sort of waiver process to encourage compliance. And then finally, you need an adjudication process where once a business amasses the requisite number of points, that there's some sort of hearing before you close them down or revoke their land use permits, effectively closing the business. If you look at the case law, there's a lot of case law of cities or towns in upstate New York that didn't have enough due process, and their laws ended up not being enforceable if they didn't have enough of an opportunity for the property owner to come in and be heard and to mount a defense. It is still against the penal law to sell cannabis without a license. One example of local enforcement would be the New York State District Attorney's Office. The New York City District Attorney's Office this summer started cracking down on local cannabis shops and seeking criminal sanctions and eventually settling with significant fines to try to curtail the illegal cannabis shop epidemic that was happening in the city. The Assembly and the Senate got in on the action and passed legislation that allows the state to go after landlords. On the heels of that, so the idea being that these shops sometimes would thumb their nose at the law, but the owners of the building have an interest, and they should be held responsible, potentially fined, etc. The New York City Council piggybacked on that, and in August they passed laws providing fines up to $10,000 for landlords for violations of the law, really directed at these illegal smoke shops. Excuse me. So that's something that's not just available in New York City. Local district attorneys in upstate New York, local town boards or village boards of trustees, city councils up here, they all have the ability to do the same sort of thing. Pass legislation making landlords responsible, using the local police and enforcement available from sheriff's departments and that sort of thing to prosecute people who sell cannabis without a license. I have had municipal clients in recent months engage in stings, the same way that you would engage in stings with people who sell alcohol or cigarettes to underage to underage people. They did the same thing with these cannabis shops, and that ended up resulting in criminal charges. So that's an option that's available to municipalities here as well. What can you do in terms of local regulation? So besides the enforcement, what sort of zoning laws, land use laws are available for you to impose that would potentially regulate this in addition to the state regulation? First, I'm going to talk about the opt-in and opt-out portion of it, because that's relevant to whether you're going to pass local zoning laws. I'm going to talk a little bit about preemption and what limitations preemption might impose on the types of things you can regulate. There's certain options under the state regulations that came out earlier this year that towns and villages and cities should be aware of. there's certain limitations on your ability to regulate hours. And finally, there's a long list of acceptable time, place, and manner restrictions that you can make part of your zoning code that don't interfere with the state regulatory scheme and wouldn't be subject to some challenge for preemption. And actually, these categories are called out right in the regulation. They're right in the cannabis law regulations that say that municipalities may regulate this activity in these particular ways. So we'll talk about that too. So first, opt-in and opt-out. I think most of you are sort of aware of this, but just briefly, pursuant to the cannabis law, cities, towns, and villages, which had the ability to pass local laws that would either allow cannabis dispensaries and on-site consumption businesses to be licensed in their community by the state or not. So there were two different categories. You could say you could treat on-site consumption businesses and dispensaries separately. And your municipality had the opportunity to make a decision and pass a local law saying that those activities were either going to be allowed or not. And the way that it worked is once those laws were properly passed and filed, they were kept on file with the Office of Cannabis Management at the state, and they just won't issue licenses to communities that opted out. Just out of curiosity, the Rockefeller Institute of Government conducted a survey. This is the result of their study, but it seems, I think it seems accurate. Is about half and half of the 1,520 municipalities in the state of New York. 753 opted out of the dispensaries, meaning there would be no dispensaries in those communities, so about half. And then with regards to consumption for on-site, it was more, closer to 900. 877 municipalities out of the 1,520 in the state opted out of allowing consumption on-site businesses in their communities. What is preemption? So what preemption is when the New York State passes a regulatory licensing scheme, local municipalities, towns, villages, cities, counties can't then pass laws that are inconsistent with it or quote unquote occupy the field. So you can't have parallel licensing schemes, registration schemes. So there's a lot of things that the state licensing structure regulates, and towns and municipalities, they can't engage in the same licensing activities. That being said, like I said, time, manner, those types of regulations, zoning laws are allowed. But the law states that municipalities, though they're authorized to adopt local laws and regulations on time, place, and manner, they can't be unreasonably impractical. So you can't zone out this activity sort of through some back door by just making it so hard that no one could ever do it. There's that test, though it's a pretty vague test, but the test in the law is unreasonable impracticability. The other things you can do that are certainly acceptable is just because it's a cannabis business doesn't mean it's immune from site plan approval. And it doesn't mean that you couldn't pass a local land use law that required a special use permit or allowed it only in certain zoning districts and not others. There's this interesting option in the law. I think after they got pretty deep in the process where they said, definitely we're going to have these restrictions on having these businesses near schools and churches, that it started coming up. Well, what about daycare facilities? What about, a YMCA? What about a Boys and Girls Club? And the state just punted. And they said, if you have something that is a public youth facility, which they don't define, they leave it to the municipalities to define, you have the option to impose the distance requirements for churches and schools on these youth facilities, however you define them, right? So it can be up to 500 feet for these other types of youth facilities. And so if you have concerns about one of these being next to like a private daycare, that sort of thing, your municipality should consider passing a local law to require these businesses to be at least 500 feet from public youth facilities. Retail hours of operation are dictated in the law. So the retail operation can't operate from 2 a.m. to 8 a.m. and you can't impose any restriction that restricts them to less than 70 hours a week. So you can trim those hours a bit, but it still has to add up to 70 hours in a week. Same thing for on-site consumption. They can actually stay open later. They can stay open until 4 a.m., but same 70-hour a week restriction, where if you pass some local law, you still have to leave 70 hours in the week where these things can be open. The acceptable local regulations are set forth in the actual cannabis regulations that I mentioned. So these are the categories that the state law actually calls out that are appropriate for municipalities to pass their own laws about. So that includes visual or architectural integrity of buildings located within historic districts, parking requirements, traffic control, that includes pedestrian and vehicular traffic, odor, there's certain preemptions about odor, but you can regulate odor and noise, and then certain distance requirements, like I said, with the youth facility option there. Visual impacts, I think, are important as part of any sort of seeker evaluation of a special use permit or a site plan application. I think visual impacts, architectural integrity, impacts on historic architecture or historic resources are all appropriate inquiries when dealing with construction of a new structure or modification of an existing structure that's going to be used to house a cannabis business. And nothing about the cannabis law, nothing about the regulations somehow takes town's ability away to, consider these sorts of impacts as part of your site plan review process, as part of your special use permit process, and as part of the seeker process, where you weigh different impacts on the community and the environment. Parking is very important. I've written a handful of zoning law amendments that deal with cannabis, and they all are very focused on parking. I think there's reasons to have enhanced parking requirements for these businesses. One reason why is experiences in Colorado, Massachusetts, elsewhere show that there is a tremendous amount of traffic associated with these businesses, particularly at the time of opening. So if your existing retail parking requirements say you need X number of parking spots, or you need a parking spot for every X square feet of retail space, you may want to ramp that way up for cannabis businesses for two reasons. One, they're exceptionally busy, particularly at the beginning when they open. And number two, the way that they're structured, not much of the space is dedicated to retail. So these laws oftentimes exempt storage and behind the counter space, and just the peculiarity of the amount of security and storage required for a cannabis retail dispensary really cuts down on the amount of retail space and makes the amount of parking that'd be required in the code without some enhancement pretty small. You may not want to do that though if a dispensary is being located in a downtown area, a walkable, more built environment where you've got lots of businesses, close together in bays. So that sort of place, well, you wouldn't want to create some draconian parking requirement there, because you'd essentially zone that activity out of an area where you may want that may be the spot in the village center, the city center, where you'd really want this business, not out in some suburban strip mall. So you have to be careful when ramping up the parking requirements that you account for that. And so how do you do that? The way that you do that is your parking requirements need to be different depending on the zoning in your town. If you've got drastically different zoning districts and different expectations about density in those different areas. Traffic control, same Same thing for any other business applies. Safe ingress and egress should be considered as part of the site plan approval process. Pedestrian safety is particularly important. If you're in an area like we just talked about, where there's a built environment, a lot of people are walking or using public transportation, that, all those things can be used just as any other retail business. You want to consider those things as part of your site plan approval and your special use permit process. And then finally, odor and noise. I mean, we talked about how busy these things are, and I'm imagining in my head right now the hypothetical of a standalone building surrounded by parking in a suburban retail zone, and you've got single family houses that are nearby or even adjacent to it. You got to consider whether or not these businesses, considering how much foot traffic they're going to have, at least in the short term, need some sort of enhanced setback requirements, or maybe even enhanced minimum lot requirements, in order to be able to place this structure in such a way to allow for adequate parking, to allow for adequate screening, since it's a high intensity use commercial activity that could be near residential uses. I think it's very appropriate, and in the laws that I've worked on, most of them have included enhanced screening and setback requirements to deal with that sort of foot traffic. Remember, at the beginning stages, there's studying one in Massachusetts. They had heightened parking requirements, but it was the parking lot was still queuing into the boulevard on a regular basis, because the business was so busy the first couple of years that they were doing this, that they ended up having off-site shuttle service to a remote parking lot, right? So, you can imagine that if that was located next to townhouses or row houses or single family residential uses, it just would be a nightmare. So you need to be mindful of where, in terms of your zoning, this use is allowed. And then even once it's allowed in a zone, in your special use permit regulations and as part of your site plan considerations, you really ought to consider some additional requirements for screening and setbacks to deal with those types of impacts and to mitigate them. So that is our hour. I will stop there. I appreciate everyone's attention. I hope this has been useful. Please don't hesitate to contact me if you have additional questions about cannabis and land use laws. And I just want to thank everyone for giving me your attention and participating in this lunch session today. Goodbye.